You've got mail.
Email. Hey, can you use email to make a legally binding contract? Well, that takes us to this week's case. It involves a real man, John Forcelli. John was involved in a car crash in New York, and there were multiple vehicles involved, and one of the vehicles involved was owned by Geico Insurance Company. John hired an attorney. The attorney sued a bunch of the people involved, including Geico Insurance Company. Now, the case proceeded, was going to court, and it was on its way, and one of the things that was pending was a motion for summary judgment. Now, under a motion for summary judgment, the parties basically bring cross motions and say, we think that under the undisputed facts, and sometimes there's a difference of opinion as to whether the facts are disputed or undisputed, but basically somebody is saying the facts are undisputed and we think we are entitled to judgment just the way the facts exist. Okay, well, that motion was pending. And while that was pending, Geico approached John Forcelli's attorney and said, you know what, we'll offer you $230,000 to settle this case. John's attorney said, okay, fine, given the circumstances, we will accept that. And the Geico insurance representative sent an email to John's attorney saying, this confirms our phone discussion, please complete the form that was attached to the email, and please prepare a release, and we're over and done with on this case. All right, well then, a couple of days later, the motion for summary judgment was decided by the court, and the court found in favor of Geico, said Geico didn't have any responsibility for the injury suffered by John Forcelli. In short, they owed him nothing. Well, John's attorney said, hang on though, hang on. They wrote an email in which they said, confirming the phone conversation, they were going to pay $230,000 to settle the case, and I would prepare the release. We think there is a contract here. They offered to settle for $230,000 in exchange for a release. We agreed to that. I said I would provide the release. We have a contract. Well, Geico said, no, we don't. No, we don't. We don't have a contract because it wasn't written. Nobody signed it. There wasn't a wet signature. That doesn't conform with the common statutes here in New York for making a contract. Well, the case went to the trial court. And at the trial court, the judge heard the various arguments, and the judge came away and said, you know what? There was an offer, there was an acceptance, there's a contract, granted it was done by an email, but everybody's using email today. It was clear what was taking place. I find there is a contract. Okay, Geico wasn't pleased with this. They took it up. They went up on appeal in New York, and there the appellate court heard this and said, you know, this is by email. The contract, if there is a contract, was put together by email and was confirmed by email, and basically, for all intents and purposes, we find that there was a contract, we agree with the trial court, and we find even though it doesn't comport entirely with the laws in New York regarding traditional contracts in which you do have a signature on a sheet of paper, everybody today is using email. It's used for both personal purposes and for business purposes, and we find that this was a very legitimate way to form a contract since the email confirmed the conversation. There was additionally an offer to provide the release as was required under the email, and as a result, we had an offer and acceptance. There was a contract. Even though it was made by email, the contract was legally binding, and Geico, you owe John $230,000. Okay, we bring you this case, we bring cases every week so you understand how the law works. I'm David Allen.